And so may I call on the representations for the appellants to introduce themselves.
Respectfully, Your Lordship, my name is Erasmus Korte, and with me, my co-counsel, and we appear for the appellant's applicant.
Thank you. For the respondent.
May it please the court, my name is Denise Lomoki Dame, and with me is Abigail.
Thank you.
Thank you. My lord, I humbly submit that on the continent, the African continent, in places like Nigeria, people go to extreme ends, like the Boko Haram, to enforce their religion by killing people. This is not what the Makuma is doing. We are not causing bodily harm. The act is proportionate and rational. It is not excessive, in that only the drums were destroyed. My lord, we believe that it can be paid for. And again, I will add that in the use of this was not a case where, okay, I would say that Article 2 of the Constitution, in Article 3 of the Constitution.
Yes.
Yes. In Article 3 of the Constitution, a person would have rights to defend the Constitution. We can take that and then, analyze here. A person from the Makuma, from the ATR, that's the African traditional religion, would have an interest to defend our religion based on this. So we submit that their use of reasonable force was justified to compel obedience to their religion. And I also say that the acts of the appellant were consistent and constant to actually warrant the use of reasonable force in this instance.
Very well.
On this note, we ask the court that in administering the freedoms of people, it also administers justice in this case. Thank you. I rest my case.
Thank you. So the court will invite your co-counsel, Abigail Abrefi Entry. I think you have about some 15 or so minutes. Okay.
May it please the court. My name is Abigail Abrefi Entry and a co-counsel for the respondent. My lord, I will tackle a third and fourth points. My lord, we submit that the Bonovian constitution is justified in saying that homosexuality laws of Bonovia and tightening the noose around seemingly homosexual activities. My lord, we would enunciate this point in other 4 points, which is the constitution is justified because major religious bodies in the country are against this principle of homosexuality. Then again, the criminal code of the country is against this principle, or they outlaw homosexuality. The cultural values and traditional values and even the history of the people is against or abhors this particular homosexuality. My lord, when it comes to the religious groups in the country, there are two major religious groups in the country who are against this principle. That's the Christians and the Islamic people. My lord, looking at the facts, the Christians form 70% of the 31 million members of the country, and also the Islamic people form 16% of the population. And my lord, in a democratic country, or a country which practices democracy, I think, I believe that the majority should.
You argue law, or is what you believe?
What?
Is it an issue of majority, or is an issue of how the constitution has been designed? Because the constitution basically is a secular constitution. It allows a secular state. It allows freedom of religion, plurality of it. It doesn't support any of them. Its laws, its constitution is not patterned according to the religious creed of the majority of the people. Otherwise, then we will take what the religious bodies have, their Bible and their Quran, and then we extrapolate everything, and that will be the constitution. What do you think?
My lord, looking at the constitution of Bonovia,
Yes.
we appreciate the fact that it's a secular constitution. However, it has in its content democratic principles. And my lord, democracy is defined as government for the people, by the people, and by the people. My lord, looking at the analysis, the number of people in the country who are members of these religious bodies form the majority. And if we are talking about democracy, there's a principle called fallacy of democracy. And if majority will always carry the vote, however, we will give reference or consideration to the minority. And in such an instance, looking at the number of people who are members of the Christianity and then the Islam religion, we think that the Bonovian constitution is justified on that ground. Then again, my lord, the criminal code of the Bonovian constitution, of the Bonovian country, outlaws this principle. With the leave of the court, my lord, I would read section 104 of the Criminal Offences Act 1960, Act 29. It said, a person who has unnatural carnal knowledge of another of not less than 16 years of age, without the consent of that person, commits a first-degree felony and is liable on conviction to a term of imprisonment of not less than 5 years and not more than 25 years. Or another person of not less than 16 years of age, with the consent of the other person, commits a misdemeanor, or of an animal commits a misdemeanor. And in that same act, it explains unnatural carnal knowledge as sexual intercourse with a person in an unnatural manner or with an animal. And my lord, we can all attest to the fact that homosexuality or gayism or lesbianism is an unnatural carnal knowledge, or knowing a person in an unnatural manner, which is prohibited by the Criminal Offences Act of Bonovia. Then again, this is the reason why we want the...
How does that affect other persons? What two persons decide to do in the privacy of their homes?
My lord...
Would the state be playing the role of a big brother, just to be watching, to know what happens in the closet of the citizens?
My lord, this brings my mind to the case of Nati versus Gatti,
Yes.
where the courts declared that lawful discrimination was permissible so long as it did not contravene certain grounds, which were gender, color, race, and the likes. However, in these on grounds of discrimination, there are certain overriding principles or interests that are protected by the Constitution and also by some international conventions like the ICCPR, which are public morality, public health, public interest, and the likes. And in the light of public morality, my lord, unnatural carnal knowledge, even in the facts of the case, is expressly mentioned that the pre-colonial era or the people of Bonovia have since history or since emanation of the inception of the country been against this principle of homosexuality or this particular act of homosexuality. And as such, I think the Constitution is justified, or I submit that the Constitution is justified in holding that.
I believe you are aware that Bonovia is a signatory to a number of international covenants and conventions. That is right.
Yes, my lord.
Yes. And Bonovia is even a member of the UN Human Rights Committee. And in a number of groundbreaking decisions, that Human Rights Committee, in Tunin versus Australia, has held that the right to sexual orientation, is a right in respect of the Tasmanian criminal code, which is not dissimilar to what we have in Bonovia. And indeed, that committee struck down that aspect of the Tasmanian code, which is a territory in Australia. And so the Bonovia also being a member of this committee, don't you think, per some of these international rulings, covenant conventions, it serves as a guide for Bonovia also probably to have a second look at some of these laws.
My Lord,
Yes.
these international principles or these international conventions
Yes.
have been ratified by Bonovia. However, we are going to base on the fact that the constitution of Bonovia, and as such, all other acts that gain their authority from the constitution are against this particular idea of homosexuality. My Lord, it is we know that in the European side or in the European countries, this principle has been accepted and people are practicing it. But my Lord, we are in an African setting, and in Africa, over 34 countries have criminalized this particular act, and Bonovia is no different. We are all in an African state, and if this act, as Africans, have been criminalized, I do not think that, or I submit that the Constitution of Bonovia is still justified on this particular ground.
And so your argument basically will be on ground of cultural relativism.
Yes, please.
You want to develop that argument further?
Yes, please, in other respects.
Okay.
And also, my Lord, I would plead the limitations, especially when it comes to public morality.
Yes.
Because looking at a natural canal knowledge, we are trying to
Yes.
the act of homosexuality, as in the facts, have been stated by the Makoma and then the ECB members as a principle of moral decay and a path away from authentic African life. And here, the emphasis is on authentic African life and moral decay. We are a community, or we are, as Africans, or specifically Bonovia, we are a community that uphold moral principles. And if this particular act is going to cause moral decay and a path away from the authentic African life, then I think it's going to breach the principle of public morality. And on that basis, we say they are justified. Again, I would look at the second issue. We submit that the traditional values of Bonovia society that
Yes.
frown on the immoral activities ought to be upheld as constitutional rights. Because, my Lord, the only way we can uphold customary rights is based on the fact that they derive their source from the Constitution of Bonovian. Per Article 11(1) of the Constitution of Bonovian, the laws of the country include the Constitution, enactments or made by or under the authority of Parliament, established by the Constitution, any others, rules and regulations made by any person or authority under a power conferred by this Constitution, the existing laws and the common laws. And narrowing it down to Article 11(2), the common law comprises of the rules of law, generally known as common law, the rules of equity, and the rules of customary law determined by the Superior Court of Judicature.
Yes.
My Lord, customary laws are rules of law which by customs are applicable to particular communities in Bonovia. And then in the case of Re-Adum Stool, that is AJ versus Ofori,
Yes.
the customs of the Adum Stool of Kumasi in Ashanti region, the Kumasi Traditional Council unwarrantedly interfered in the practice of custom. So it's per Benjamin Hayfron, his dissenting opinion, he asserts that it's of very great importance because Nananum unwarrantedly interfered in the practice of custom. And then they, by applying logic to a hallowed custom of Aite, claiming that it is a novel proposition per Benjamin Hayfron, JS, was not right.
Okay.
All right.
You have 2 minutes to wrap up.
And Article 26(1) of the Bonovian Constitution also provides that every person is entitled to enjoy, practice, profess, maintain, and promote any culture, language, tradition, or religion subject to the provisions of this Constitution. My Lord,
Yes.
based on this particular article, we submit that the constitutional rights, the traditional rules, or the traditional values must be upheld as constitutional rights if there are immoral activities that are frowned upon by members of Bonovian country. However, someone would ask, how does a customary law gain gains stance or gains the opportunity to be called or to be called a constitutional right, we would, even in international law, the test for customary law to gain the right to be customary is that it must be based on general practice of the states, and then the states must have accepted it as law. And looking at this particular act, I traced it from the history of Bonovia and also on the principle of the democracy of the country in conformity with international laws. I submit that the immoral acts or the acts that have been frowned upon by the traditional customary values of Bonovian society, such as homosexuality, is or ought to be upheld as
All right.
constitutional right.
Thank you. All right. I think I reserve the discretion to grant no more than 5 minutes to each group, both the appellants and then the respondents, just probably to summarize or probably to add a point or two. You are not at liberty to take it, but if you want, I will give it to you. 4 or 5 minutes. Yes.
Your Lordship, we are grateful. Respectfully, Your Lordship, counsel for the respondent alluded to the fact that the appellants had been admitted, and the facts do not fall on all fours with the Rasmagai case. We find this absurd, Your Lordship. It is even more dangerous that students who have been admitted, you have to suspend them because of hijab. Your Lordship, this is in clear breach of their educational rights enshrined under Article 25 and 28(4). And same should be declared unconstitutional. Your Lordship, they further admitted that indeed Makoma people only destroyed the properties of our applicants, and for that matter, only damages will suffice. We think that this is a show-off. This is indeed a disrespect to the court, to the extent that you can destroy property because you have money to pay. My Lord, exemplary punitive measures should, indeed punitive damages should be subscribed against them so that they would not engage in that criminal enterprise, which is in affront breach of Article 74, Section 74 and 76 of the Criminal Offences Act. Your Lordship, it is again our contention that homosexuality in Bonovia existed even in pre-colonial days until an act was passed that sought to criminalize same. We have been in this country where the doctrine, the concept of Sankofa has been with us for a long time. And indeed, if we are in a secular state such as this, there is nothing wrong going back for our value. These things that used to be there.
Were they values in the past?
Were
they are values in the past? Were they recognized, even if they existed? Were they done under cover of darkness, such that those that even did it, they were afraid to expose themselves? And now you think we should shine the light on them and bring it to the fore?
Your Lordship, it is not our contention that we should throw more light on them. Our contention is that these are rights that ought to be recognized as such.
I told you never convinced me if indeed it was recognized as a right.
Your Lordship, Bonovia, as you rightly mentioned, had subscribed, acceded, and then rectified many international conventions.
Yes.
That seeks to
Is there any international convention that accepts that act as a right? Because I thought you would also have addressed me in that respect. Whether is any Universal Declaration of Human Rights, did it mention any such? Whether is the International Covenant on Civil and Political Rights, do we have any of such? Is there anything at all? Whether it's the Maputo Protocol, whether it's the African Charter on Human and People's Rights, does any of these covenants, charters, prescribe that as a right? Such that you can import it into
Your
Bonovian society. Do we have that?
Lordship, Our contention is that
Anyway, I think your time may be up, so you wrap up.
Very well.
Okay.
Thank you.
Yes, for the respondent. Yes, Ms. Lomoki, do you have anything to say in rebuttal?
Yes, please. On
Very
the
well.
sexual orientation,
Yes.
the conventions, the international conventions, allow us to limit some, in fact, allows us to limit some rights based on public morality. And we are speaking.
Which are these?
Please come again.
Which are some of these international conventions that you claim allow Bonovia to limit on grounds of morality, ethics, some of these conduct or activities?
The International Covenant on Cultural and Political Rights.
The International Covenant on Civil and Political Rights.
Civil and political rights.
Does it say any of such? It is stated its provisions in broad, general, and what I would say hortatory language. Does it specifically state this that you are alluding to?
I would allude to the general comment number 34 of the International Convention on Civil and then Political Rights,
yes,
which allows states to restrict the exercise of association by any laws that are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health or morals, or the protection of the rights and freedoms of others. On the public morality, in Ghana, we can take in Ghana, the Christian Council of Ghana issued a statement on July 29, 2021, stating that the effect to the effect that homosexuality is a detestable and abominable act, and they did not assent to it. The chief imam of Ghana too made a statement on behalf of the Muslim community of Ghana condemning homosexuality. When we bring it into the statement of facts, the Christians and then the Islamic community do not accept homosexuality. And when we take, incidentally,
but somebody will say, as I sit here, I do not sit here as an ecclesiastical judge, and the court is not an ecclesiastical court; it's a secular court of Bonovia to dispense justice according to the laws of Bonovia.
Yes.
Why should the courts or the judges be held hostage by the views and opinions of religious groups? Otherwise, very soon, what they don't like will be what they will be dictating to us, that it should be our laws. So instead of they preaching to their congregants as to what is right or wrong, they would want it to be law for the judges then to implement what they can do in their places of worship for them. Is that not what that will lead to?
In paragraph 6, the Bonovia is a multi-religious country and boasts of about 70 of its population being Christian, 16 being Muslims, and a sizable being African traditional religion. These are mainly the population or the sections of the country, and they all do not subscribe to homosexuality. This is an issue for the people, and the people do not accept sexuality because homosexuality because it is not the authentic African life. Because of this, then the other international conventions, homosexuality cannot be forced down the throats of the Bonovian state or the people of Bonovia. We humbly submit.
Very well, thank you very much. Okay. I think the court will go on recess for some few minutes.
Court rise. Court ready. Silence for His Lordship, the Justice of Appeal Court.
Very well. The court resumes. Before the verdict of the court, there are some comments that the court intends to make. Number one, I think the court is reasonably impressed with the quality of legal arguments from both sides, both that of the appellant and that of the respondents, and we must applaud ourselves for that. Beyond that, I think I have also had a look at the written submissions of both lawyers for the appellant and the respondent. And within that short period of time that you had to work on the MOOT problem, I think that is also quite impressive for the kind of industry and the amount of scholarship that you have displayed in both the written submission of the appellant as well as that of the respondent. And I think, again, well done. Okay. Having said that, in respect of the written submissions and then the oral argument before the court today, there are some few comments I have put down that before the verdict I intend to share with you. Regarding the issue of Nick and another in respect of the LGBT issue, both in respect of the written submissions and then in respect of your oral argument, I had expected that as to whether or not the homosexuality being a right or not a right that should be enforced by the courts of Ghana, that the argument would also have been elevated in a way by looking at it either as a universal right or as a cultural relative right. In other words, some kind of arguments were raised, especially in respect of the submissions of Ms. Abigail Abrefi-Entry. That being Africans, this is the way we look at it. But you are in a court of law, and you are here to speak law. And so you place it within the proper context of rightly saying that it is a cultural relative right, and then you begin to justify it as such. It is only when you begin to proceed from that angle, then you can argue that there is nothing like a universally accepted right of LGBT, that none of the international conventions, that none of the declarations appear internationally to accept this. When you proceed on that angle, as I said, then you are truly arguing law. And so I thought I would have had more in both the written submissions and then the viva voce submissions before me today. Beyond that, during my interactions and then questions with you, again with respect to the respondents, there was a strong argument that I thought if you had taken a little bit of time and checked the jurisprudence of cases coming from the European Court of Human Rights, even in Europe, that one may think appear to be relatively homogeneous. Some of these cases had appeared before the European Court of Human Rights, either from France or from Turkey or from Greece. And they had invoked a principle of what we call margin of appreciation. It's a species of cultural relativism. Margin of appreciation. So, for instance, we have this case of Sahin versus Turkey. S-H-A-H-I-N. Sahin versus Turkey. Where here the appellant before the European Human Rights Court, he was sanctioned for wearing Islamic headscarf at a university. She challenged this before the European Court of Human Rights. And the European Court dismissed the case on the ground of this principle of margin of appreciation principle, that there was no uniformity even in Europe as to allowing it or not allowing it. And in that context, the court would allow, within proportionate terms, Turkey to ban it in their universities. You could have also looked at the case of SAS versus France. That was also on a ban on the wearing of the burqa in public. Again, that same court held that there was not yet an European consensus on that issue, and that France was afforded a margin of appreciation so far as the ban was proportionate. You could have also explored the case of what we call Kokonakis versus Greece. And this had to do with Greece anti-proselytizing law, where it banned certain Christian religious groups from going to homes of citizens in an attempt to convert them from the Greek Orthodox Church. The European Court again held that the ban was proportionate because of this principle of margin of appreciation. I would have been more delighted if you had explored that angle of argument and then you had brought it within the local context and argue in respect of this margin of appreciation. And that could have gone for in respect of the ban on noise making, in respect of the homosexuality laws, and even in respect of morning glory. As to whether or not it would have found favor with the court is another argument. But I thought you should have explored that angle. And again, even with the appellant, I thought you would have also introduced this angle and probably set out any distinguishable features which makes it inapplicable under the Bonovian society. Again, in respect of the LGBT issues, I had thought that the main argument in respect of sexual offenses that calls for proscription, you'd have touched on it. Is there lack of consent? If there is no lack of consent, then if it's adults, that will be rape. If there is no capacity, so a minor may not have the competence to engage in it, then the necessity to avoid exploitation of the vulnerable and the poor is that here. And then the preservation of public decency. I thought these are the four parameters within which any proscription in respect of criminal activity lies when it comes to any of the sexual offenses. And then you situate it within the context of a ban against any homosexual conduct, whether it infringes any of these four. If it doesn't, how then can you argue? Again, you could have fallen back on the issue of margin of appreciation. I heard much also about secularism. There was an attempt probably to define the scope of secularism. And I thought that could have also been explored further. It is not a promotion of religion, but it is independent of religion. It is a recognition of religion, but not an active promotion of religion. It affords a platform for equal treatment of all religions. And so if the Constitution is a secular one, then that becomes the platform then for you to argue, either for or against in respect of this. You could have also further explained in terms of pluralism, which may be a little bit different from secularism. It's a social construct. And that shows the otherness of others, that we are all not the same. A principle of coexistence of diverse religious bodies, and the assumption that two or more religions with mutually exclusive truths claims are equally valid. And so tolerance, let them be there, which in a way is different from secularism. Yes. And then you place it within the context of Article 2126. I kept asking, in respect of freedom of thought, conscience, and belief, that indeed there is no limitations whatsoever. And that is what is termed as the internal forum. You are free to harbor any religious belief you think is right for you. That besides you, all other human beings are rats. You can believe that. But when it comes to freedom of expression of that religion, that is manifestation. And when we are talking of manifestation, then we are dealing with worship, observance of worship, ceremonies, rituals, holidays, manner of dressing, wearing of a hairscarf and all that. That is manifestation. When it comes to that, the example I gave, you can believe that all other human beings are rats, but you will not be allowed to manifest it. Manifest it in such a way as probably taking a cutlass that you want to kill all rats. That is how you want to manifest it, because it is in conflict with the rights of others. So as far as freedom of expression in terms of religious beliefs is concerned, there is a limit. So in terms of being proportionate, safeguarding the rights and freedom of others, public health, public morality, as spelled out by the Constitution, all those come in. Again, I had expected that you would have fully explored that angle and seen whether in terms of manifestation, it is proportionate if it's a ban on noise making. The attempt to enforce it in terms of manifestation of that belief, is it proportionate? Does it come into conflict with the rights of others? Can it be justified? So I had also expected that angle to have been explored. But all in all, I think you have done yourself extremely well. I have seen lawyers with quite a considerable number of years' experience at the bar, and yet when they come to court, they fumble, more especially when they are not allowed to go according to their prepared text that they have before them. Just when they rise to their feet and then you ask one or two questions, some of them are probably diverted, of course, when the judge keep asking questions. But I recognize that most of you stood your ground. You tried, attempted answering the questions was put into you. And I will urge you that you should continue in that same spirit, because that is the way you build your confidence in the law. And finally, I think for the lead advocates, for both the appellants and then the respondents, I am extremely impressed with the level of the confidence that you exhibited, either in your delivery as advocates or in the manner or way you attempted answering the questions that I asked you. And equally, even for the supporting advocates. Thank you very much. And in terms of the results, it is not so much about either you win, you lose. In a contest like this, surely there can be only one winner. But I must make an honest confession. You have really made it difficult for me to judge as to who is the winner and who is not the winner. There is no loser here. There is no loser here. I was asked to judge you based on a number of factors. One, in terms of your written submissions, which I have read. And I think looking at the parameters and the various areas I have pointed out, I think in terms of the written address, out of a maximum of 30, I awarded 22 marks to the appellant, and then for the respondents, 20 marks. In terms of preparation and familiarity with the 3 consolidated cases, out of a maximum of 5 marks that I had the discretion to award, I awarded both the appellants and the respondents 4 each. Before the court today, in terms of the structure of legal arguments, and I think out of a maximum of 5 marks, I awarded 4 for the appellants, 5 for the respondents. Knowledge and application of the law. Out of a maximum of 20 marks, I awarded 15 for the appellants, 13 for the respondents. In terms of organization, presentation, and speaking ability. So you see 3 were put together, not only speaking ability, presentation, the organization. I gave 15 for the appellant, 16 for the respondents. Responsiveness to questions, I thought it shouldn't have been 5 marks, it should have been more, because that is what shows who a good lawyer is, because the lawyer is able to think on his or her feet rather than coming with a prepared one. And in future, I think that should also be increased. In respect of responsiveness to questions, I awarded 4 out of 5 to appellants, and then 3 out of 5 to respondents. In terms of persuasiveness and advocacy, that was also a difficult area for me to score. But out of 10, I awarded 7 to the appellants, and then 6 to the respondents. And then courtroom etiquette, that can be in terms of answers to questions, mannerism, way of speaking, engaging the bench, or just playing to the gallery. Everything is involved. I was given the discretion to score a maximum of 5. I scored 4 out of 5 for the appellant, and then 5 out of 5 for the respondents. Okay. Putting all together, I think this is what I have. For the respondents, out of a score of 100, they had 72 marks. And then for the appellant, out of a score of a possible 175 marks. But this year too, it is my singular privilege to declare University of Cape Coast as the winner of this year's MOOT competition.